Welcome everybody to the data protection course for human research. I'm going to briefly introduce our speaker today, which is Simon Parker. He has a bachelor's in history and a master's and PhD in criminology. And he's been a data steward for GHGA since January 2021. And he is currently our data protection coordinator. And he will be talking us through data protection for human research today.
Thank you, Julia. Yeah, welcome everyone. Thank you for being here, and I hope you find what we're going to cover today to be interesting and informative as well. Okay, so a little introduction. The idea really behind this course is to give you an overview of data protection law. Primarily, we're going to focus, of course, on the GDPR since we're based in Europe. We'll be covering 5 areas in total. The slight caveat I would say on that is that we're going to cover 4 together, and then there's an additional module or an additional section that will be only really for GHGA staff, and we'll be going into more about the data protection that we use internally. And so if you're not a member of GHGA, you're free to leave at that point if you wish, but of course if you'd rather stay, then yeah, you can listen in. It just won't necessarily be as relevant to you. We do have, as Julia mentioned, a fair amount of time for discussion around these issues. We'll have a pause at the end of each of the sections so that you have time for questions, and we have some kind of discussion activities within the sections themselves. I guess kind of a warning, obviously we're not going to necessarily go very deeply into the legal text of the GDPR, so I guess that's probably more something people are afraid of. But we will try and cover some of the details when it's essential to actually understand what we mean and why we're doing things. So we're not going to get bogged down into the minutiae of the legal text. So our learning objectives really for today is in the first module and section, we really want to understand what is meant by personal data and why some personal data are categorized as a special category. We'll then be looking around the legal bases with regards to personal data processing and what they are. So the kind of lawful routes through which we can actually process personal data. We'll then look at some of the different roles that are sort of described in the GDPR and what they have in relation to personal data processing and their obligations. We'll also cover the rights of data subjects and how they are exercised. And then finally, in the sort of additional module, we'll be looking at how personal data is protected within GHGA and going into more detail there. Okay, so part 1. So what is personal data? Well, I wouldn't go, as I said, I won't go too much into the GDPR, but we do have to have a little bit of an introduction to it. And the GDPR came in and it covers the legislation, across the EU and EEA. But it actually applies to EU and EEA citizens wherever their data is processed. So although the GDPR primarily applies to those regions, it's really applying to the citizens. And so even if your data is being processed in the US or anywhere else, it would still be covered under the GDPR. It was adopted in April 2016, and it came into force in May 2018. It's directly binding and applicable. And so what this means is that it came in and it didn't need to be implemented locally, but there is some flexibility to adapt some aspects of the regulation in member state law. So there are certain requirements for legal bases, for example, which are based on there being a law to enable that kind of processing. And of course, that law needs to be implemented locally. So it's not something that can be brought in at an EU level. In Germany, the GDPR is implemented at the federal level via the DSGVO, and actually it's also within the data protection legislation of each federal state. So by and large, these are very similar. There are some slight differences, of course, across each federal state, but generally speaking, the key points of the GDPR are going to be the same across all of the federal states of Germany. So personal data, and personal data is defined in the GDPR as information that relates to an identified or identifiable natural person. So that person has to be living, as described in Article 4, and they're usually referred to as a data subject. So you may notice there's a little asterisk next to living there. And that's really because there may be some contexts in which the personal data about someone who is no longer living could actually impact on the rights and freedoms of other persons. And so there may be times when we have to be a bit careful about using data that's been that came from a person which is now deceased. A classic example of this would be something like genetic data or some kind of health, some forms of health data. Genetic data obviously is strongly linked to your relatives. So a whole genome sequence for yourself would be very closely matched to someone who was your sibling or even your parents. And so if there are hereditary diseases or things like that which are found within your data, even if you were deceased, that could the revealing of that information could potentially have an impact on the rights and freedoms of persons who are still living. And so sometimes we do have to be a little bit careful around that thought that actually if someone is deceased, then we no longer really have to think about data protection. What's really crucial as to whether the GDPR applies is whether it's possible to identify or even re-identify a person from within that data. And so it doesn't necessarily matter if the data is about a person, unless that person can be re-identified from that information. So just person level information in of itself is not necessarily going to be considered to be personal data. The way that the identification can happen can be either direct or indirect. And so indirect identification will typically use multiple pieces of information in combination. And we're going to see an example of that in a moment. Direct identification, as the name suggests, means that from the data itself, it's possible to identify someone directly. So, for example, if a data set contained your name, your date of birth, and your address or your postcode or something, that's fairly clearly going to enable a direct identification of that individual. Whereas indirect information might be that you have to combine different sources of information together. The other aspect of this is always to think about it is reasonableness. And so the GDPR doesn't typically deal in absolutes. And when it comes to identification, there is a kind of gray area that's built into the law. And this is described actually in one of the recitals, which are kind of information that goes along with the GDPR, recital 26. And what this argues is that the likelihood identification has to be kind of reasonable. And what this is taken to mean is that there may be circumstances in which data could be re-identified, but it's whether the methods that would be required to do so are reasonably likely to happen and a reasonable effort. We wouldn't expect, for example, if someone was trying to work out my salary or something like that, some personal data about me directly, that they would have, 1,000 researchers working on it and access to supercomputers and spend years trying to bring together lots of very disparate and small bits of information together to piece something that would be considered unreasonable. And so really when we're thinking about whether data are personal, we have to think, okay, what's reasonably likely to happen? What reasonably likely exists that someone might have access to that could be used to re-identify someone in this data set? So it's something I think perhaps people don't think about too much about the reasonable likeliness. There's perhaps a trend for people to think that any likelihood of identification means it's a problem, but actually recital 26 is very clear that it's really about what's reasonable, and if it is in some way and hypothetically possible to identify someone, it doesn't necessarily mean that that's personal data. So direct and indirect identification. So if we had a data set that looks something like this, so you can very clearly see we've got a name, we've got an office, we've got my position, my age, not really, obviously, and my annual salary. It's very easy to identify someone from this data because we've got these direct identifiers in the data set. If, however, we only had this information, suddenly it becomes much harder to identify someone, but not impossible. And so we can see that there's someone with the position of data protection coordinator in that office, and we know their annual salary. Now, of course, this doesn't offer us very much protection because we can go to that office and we can see, okay, the data protection coordinator is in that room and we know their name. And so in this way, we've indirectly identified myself, because we've used these different sources of information in combination with each other to identify myself. And now what we can do is perhaps what would be the more interesting part of using this data is work out my annual salary, which is perhaps the bit of information that's of most interest here. Now we've talked or mentioned really personal data, but I think we can perhaps think that there are some data which are going to be more sensitive to us than other bits of personal data. And the GDPR takes this into account. And so it actually specifies that certain types of data or data about certain topics is more sensitive than other forms of personal data. And this is set out in Article 9 of the GDPR. And these topics were selected because they're sort of perceived to be more likely to be sensitive to people, or because the information actually increases the risk that they could be used to re-identify someone. So it could be something which, like a genome, for example, or something which is very unique to an individual, such that it's very likely to lead to the re-identification of someone. The GDPR refers to these as special categories of personal data, and there are additional restrictions around the processing of these. So we have in the GDPR personal data, and we have these special categories of personal data, and there's additional protections which are required when we're processing these special categories. And there are actually 8 categories of data which are described in Article 9 as a special category. But we can see kind of the trend therefore is really information, as I say, which is either going to be highly identifiable, such as genetic data or biometric data, or data which potentially would enable someone who has had bad intentions to disadvantage you in some way, or either through kind of discrimination or blackmailing or something like this. All of these things are considered to be a special category because of those potential harms that could come to you. So the law is kind of set up to try and protect you as data subjects really from as much harm as possible. Now, you've probably heard of the ideas of sort of anonymization and pseudonymization, and these are really approaches to reduce the potential for data to be used to identify a data subject. So anonymization refers to the process of manipulating personal data such that it's no longer personal. So this could be done by, for example, removing directly identifying information. You could also start aggregating some of the variables. You could suppress some of the information and other similar techniques. The idea is that you go from data which would be considered personal in that it's within a reasonable effort to re-identify someone to data which is no longer a reasonable effort to re-identify someone. So typically it's done by sort of removing information. So for example, removing direct IDs like your name and things like this from it. But if you have an unusual combination of variables, sometimes you have to use other techniques as well. So for example, you might have some very broad categories of, say, cancer status and gender or something like that, or sex, which generally speaking is not going to be hugely problematic. But if you had, say, a combination of a male person, perhaps if you've got youngish age as well, with breast cancer, that's pretty unusual. And so even those broad categories could potentially be a problem. And so that's where you really have to think about when you're manipulating personal data to make it non-personal. It's not just a case of removing direct identifying information, but also looking at the other categories and seeing, do I have sort of these unusual combinations, or which combinations which are going to be less common in the wider population, such that actually even very broad categories might be a problem for these particular people. One example we used to use a lot in the UK when we were considering these sorts of problems is the idea of someone having age and marital status in a data set, and someone being 16 and a widow. So implying that they were married, but their partner is now deceased. Sort of, I think some of the modeling of the census suggested that you'd probably have maybe 5 to 10 of those people in the UK out of a population of 65 million. And so even that very broad information could potentially be identifiable because it's so rare in the population, hypothetically. And so that's why you really have to think about these things when you're performing something like suppression. It's the combinations as well that are problematic. Pseudonymization is more the process of removing the directly identifiable information from a data set, and typically you would then replace that data with pseudonyms. So you might take out a patient's name from a data set and replace it with like a sample ID or something like that. The problem really is that pseudonymized data can still be considered to be personal depending on whether other protections are in place. And so pseudonymization in of itself doesn't make personal data non-personal. It's really, again, thinking about what those reasonable risks are around the use of that data. So for example, if we had patient data and we took out the patient's name and we replaced it with sample ID, yes, it perhaps directly identifiable is now much more difficult. But if we keep a file where we have that person's name and their sample ID without any protections in place, then actually it's not that unreasonable to think that someone who is motivated could access that data and therefore work out who those people are that we've replaced with sample IDs. And so therefore we really need to think about all the protections that we have in place and what's reasonably likely to occur as to whether we can think of pseudonymized data as being personal or non-personal. So general principles of the GDPR as well, there's an expectation that we have data minimization. And so this means that we're only collecting data that's sort of required and necessary to achieve the objectives of the proposed processing. So if you're doing a particular research project where you're looking at a particular question, it's not considered to be good practice within the GDPR just to collect all the information you can about those people, whether it's relevant for the research question or not. You really should be very narrowly focused in the information you're collecting and making sure that you just collect the variables that you need and no more than that, because the more information you have, the greater the risk to the data subjects. And so we're trying to avoid sort of unnecessary risks for the data subjects. Wherever possible, you should minimize the risk of disclosure through pseudonymization or anonymization. So if you don't need direct IDs for your processing, perhaps you can remove them and replace them with pseudonyms. Or actually, if you can address the purpose of your processing using anonymized data, then the expectation is that you would anonymize the data that you've collected. Because it's about the unnecessary risk that would have if you're keeping hold of personal data, even though you could actually address your processing purpose with anonymized forms of that data. And of course, there is an expectation around security standards within the GDPR. It doesn't necessarily define those standards, but it expects you to have appropriate security measures to protect the data. So for example, you may have to think about things like access controls to the data. So making sure that only certain people can access the data, that you're storing it in an encrypted form or that it's encrypted in transit, or that you have technical processing restrictions. And these are particularly important for sensitive personal data, so the special categories of personal data. Again, it doesn't necessarily define these in GDPR, which is perhaps not super helpful, but it's about thinking, okay, what's the risk that's in the data? And have I put in security measures and protections which mitigate those risks as well as I can? And it's part of the process, as we'll come on to, that may be your responsibility if you're a data controller to actually really think about these and do a proper assessment of whether these controls and security measures are adequate. So quickly about this section. So we've just really looked at what's meant by personal data under GDPR. So hopefully you should all know now that it's personal data is data which is about a living individual, usually, that is identifiable from that data. We hopefully know the difference now between direct and indirect identification. So a direct identification is just we have a single data set or a piece of data and we're able to identify the data subjects, or indirect where we're using data sets and sources of data in combination to try and work out someone's identity. We've discussed a little bit about some of the types of data which are considered to be more sensitive, and so hopefully you can remember some of those. Perhaps the more unusual ones are the ones people tend to remember, things like trade union memberships, which people might not think about, but yes, are included. And we should have an idea as to the difference between anonymization and pseudonymization. So anonymization is where we're making the data so it's no longer identifiable or no longer linked to an identifiable person. And pseudonymization, where we've replaced direct IDs with pseudonyms, but we have to then also consider about the protections we have in place for those pseudonyms as to whether we consider the data to be anonymous under the GDPR. Okay, we will move on then. We're going to now discuss some of the legal bases for processing data. So the big question is always, can we process personal data? And the GDPR considers that any action that's performed on personal data to be processing of that data. So it doesn't just mean, I know we're sort of speaking primarily from a research context, they're actually performing research or analysis on that data, whether even if you're just collecting the data or if it's just passing through your systems and things like this, there's an argument that you are processing data. And so we need to really think about then, can we do that legally and lawfully? So as it says there, even if you're just collecting and storing the data, even if this is in an automated way, it would still be considered to be a form of data processing. So I know we tend to think of processing as actually doing our analysis, but that's not the case under the law. It's a much broader view of what it means to process personal data. And actually, the way the GDPR is worded, it states that it's actually forbidden to process you're forbidden from processing personal data by the GDPR, unless, and there's the big sort of caveat, certain conditions are met. And so the default position is that you can't do it unless these conditions have been met. And these conditions include having a legal basis for the processing. And so we're going to talk about these legal bases now. So you need to have this sort of lawful justification for why you're doing your processing. And the legal bases sort of provide some of that lawful justification for that processing to take place. And so if you go to Article 6 of the GDPR, there's actually a list of them, of the legal basis that you need for processing personal data. So 6.1, Article 6, Clause 1. If you're processing special category personal data, as we've discussed, there are sort of different legal protections that are in place around the special categories. And so actually you need typically two legal bases for processing special category data. So you need a legal basis under Article 6.1, so kind of standard one for personal data, but you also need a legal basis under Article 9, Part 2. And so when you're processing a special category, you need to think about both. You can't just have one or the other. Now, Article 6 gives us 6 legal bases that we can use. And so these are consent. So the data subject has given their consent to the processing of the personal data. And it's probably the one that we're most familiar with and perhaps the one that is most commonly used. So effectively, someone has to give a kind of, freely given specific consent, which to actually enable us to do the data processing, and then we can process in line with that consent. We can't really go outside of that consent. 6.1b gives us a contract, and so this means that if we're processing for the performance of a contract of which the data subject is a party. So if you have a contract with someone, they obviously need to process personal data about you in order to fulfill that contract, and that could be covered under 6.1b. A legal obligation, so if it's necessary for compliance with a legal obligation to process the personal data, I mean, typically this would be something like maybe if there was a court case or something and we had to provide information. It could also be, for example, your employer is obliged to process personal data about you in order for tax to deal with the tax on your earnings and things like this. And so there's a legal obligation on them to actually do that processing. Vital interest, so processing is necessary in order to protect the vital interests of the data subject. This one would typically be used in something like a medical emergency or a disaster situation, whereby actually being able to process data about people might be fundamental about whether you can protect them, keep them alive or not. So, for example, if you're rushed into hospital, it wouldn't necessarily make sense for them to stop and ask your consent to process your data if it was, a life or death decision kind of thing had to be taken quickly. And similarly, in a disaster situation, there may not be time for sort out other kind of legal pathways to process data, but it might be necessary to process personal data. Public task, so this would be processing is necessary for the performance of tasks carried out in the public interest or in the exercise of a public authority. And so if you are a institution which has an official capacity, so for example, like a government agency or something like that, you might be having a public task to do where you're actually doing something on behalf of the public and have a kind of an official authorization to do so. And finally, the one Philip mentioned was legitimate interest. And so this is when processing is necessary for the purposes of legitimate interest pursued by the controller. So this one is perhaps one that gives you a fair amount of flexibility. And essentially what this means is that you have to be able to demonstrate that you have a legitimate purpose for processing that data that kind of outweighs the risks to the data subject. So it doesn't just mean that you can say, oh, I have a legitimate interest, therefore I can process the data. You have to demonstrate why that legitimate interest is greater, as it were, than the potential risks to those data subjects. So we're going to do another kind of discussion point. Follow-up interview. What would be a suitable legal basis for processing? Let's have a look. Yes, consent here is probably the one that makes the most sense. I think as well, there's probably an expectation from people that you would ask them about this, but you know, because it's a follow-up interview and kind of perhaps inconvenient on their time. So yeah, consent here probably is the one that makes the most sense. Okay, and the last one, a charity wishes to use data collected by a public authority about local residents in order to tackle a particular issue. It would not be possible to speak directly to residents due to budgetary and time constraints. What would be a suitable legal basis for processing? Okay, so for this one, I went with legitimate interest. And the reason I went for legitimate interest is because a charity typically is not founded under law, so they don't necessarily have a kind of legal authority to be processing data. However, in this case, they can make an argument that what they're trying to do is to help people. And so if that's part of the mission of the charity, they have a legitimate interest to process that data, and the benefits that would hopefully be realized by those residents would outweigh the risks to them. So I used to work for a charity before joining GHGA, and we use legitimate interest primarily as our legal basis for processing, because we were trying to protect people and help people who had cancer. And so it made sense for us to be able to access health data using legitimate interest as one of our legal bases to do so. So yeah, I know it's not necessarily one that's so common in Germany, but it's absolutely within the law that you can do that. Okay, so Article 9. When we're processing special categories of personal data, so some of the categories we saw earlier, you also need a legal basis under Article 9. So you can't just rely on your Article 6 legal basis. And there are 10 legal bases described in Article 9 that you could potentially use. Again, some of them are perhaps more relevant than others, and some of them are kind of slightly, would be slightly niche use cases. So perhaps the main ones that would be relevant for the kind of research, depending on what you're doing, would be 92A and 92J. So 92A is consent. So that's one of the big advantages of using consent, is that you can use consent as a legal basis under 6.1 and under 9.2. The other option would be J, which refers to archiving of data and for kind of scientific use and research purposes. So when I mentioned previously working for a charity, we used legitimate interest as our legal basis under Article 6, and we used J typically as our legal basis under Article 9, because we were doing it for research and scientific purposes. So, you know, if you don't have consent from people, it might be that a similar kind of, 6.1F and 92J is a suitable way for you to be able to process that data, because it means you have to demonstrate your legitimate interest in doing so and why it's right for you to do so, but then you have a certain amount of freedom to do so for research purposes. So some of the other ones, again, there's the vital interests of the data subject. If there are political, philosophical, religious, or trade union aims. So as we mentioned, those topics are considered special categories. And of course, trade unions need to be able to process information about their members, and same for kind of religious groups and things like this. There's also E, which is somewhat unusual, and that's that if it's made public by the data subject. And so if there is data which would be considered special category, but the data subject themselves has made it public, that kind of can be a legal basis for processing as well. So it's perhaps an unusual one, but for example, if you posted your whole genome sequence online yourself, technically there could be the case that it could be processed under 9(2)E because you've made it public. There's also things around substantial public interest, and preventative and occupational medicine. We might think of these ones and I as well as relating to things like pandemics. Obviously, there is public interest in sharing medical data for addressing pandemics and for kind of these big public health incidents, as they were, that might require us to share personal data. Now, I mentioned a little bit about consent, and as I say, it's one of the good things about it is that it can be a legal basis under Article 6 and Article 9, which is one of the only legal bases that applies to. It's also really useful because it can be used as a legal basis for transfers to other countries which are subject to the GDPR, because some of the other rules require the other legal basis require implementation under member state law. They're not always exactly the same. So if we think of something like a legal obligation as a legal basis, the legal obligations are going to vary across countries as to what qualifies as a legal obligation. So the way that the laws are written vary. And so it won't necessarily be the case that you can then transfer data between countries using some of those other legal bases, because actually some of the underlying legal aspects might differ. Whereas consent, because it's kind of considered universal under the GDPR, is basically enables you to do those transfers relatively straightforwardly, because the consent principles would apply in Germany as they would apply in the Netherlands, and so on and so forth. The consent must be freely given. It must be specific, informed, and an unambiguous indication of the data subject's wishes. So what we mean here is that there shouldn't be, for example, any penalties to the data subject if they don't want to give their consent. You should be specific as far as possible. So for example, it's not just a case of someone saying, I want your consent to process your data. It needs to be setting out kind of what the purposes are, though that can be relatively broad. Who is going to be processing the data? Again, that can be relatively broad. And kind of how it's going to be processed. So actually, I think Andreas is in the meeting today. So Andreas is kind of our expert on consent within GHGA and has developed some consent modules. So what we're trying to do in a research setting as far as possible is, whilst we want it to be consent to be specific insofar as meeting our legal obligations, of course, we want it to be also slightly broad as well, and trying to find that balance between them, because we want the data to be able to be reused for research purposes. And so having it very, very precisely defined as to what it can be used for may inhibit future reuse. And so it's very much a balance there. Should also be informed, so the data subject should have information around how the data are going to be processed, and again, the information about who's going to be doing the processing and in what settings and all that sort of thing. And it has to be an unambiguous indication. So typically it would be a case of, please tick to say that you would, or tick to say that you would grant your data to be shared for this purpose, or tick to say that you don't wish it to be shared. You can't have kind of it ticked by default for data sharing and expect data subjects to opt out. It needs to be a case that they have to actively tick to say that they want data sharing to happen. And one of the other aspects of that is that you then need to record and monitor that consent to ensure that it remains valid. A data subject has the right to withdraw their consent at any time, And so you need to make sure that you are keeping a kind of a record of those consents, so that if someone does withdraw their consent, you know that that data cannot be published or cannot be processed. It could be the case that someone then gives their consent, so it becomes something of a slightly dynamic record. Now, I've mentioned briefly international transfers, and generally speaking, they are permitted to countries which are subject to the GDPR, but it needs to be that the legal basis is implemented in the destination country as well. So you can't have one legal basis in one country and then it gets sent to another country and a changing legal basis. For countries which are not subject to the GDPR, or international organizations, again, which wouldn't be subject to the GDPR, the transfers can be permitted as long as there are safeguards in place. So the GDPR sets out that you can have adequacy decisions, and these are whereby a particular country, for example, has been judged by the European Commission to have good safeguards in place for data protection, such that they are equivalent to the protections you would have within the EEA and EU. So we can sort of say that the data that's transferred isn't suddenly under less protection than it would be within the EU. There's actually not that many countries which have adequacy decisions at the moment, and so it's not something which you can generally rely on there being one. A lot of countries haven't achieved that standard or haven't been assessed to achieve that standard. There's also the possibility of using standard contractual clauses, which sort of bind the recipient of the data to adhere to the principles of the GDPR and to the regulations of the GDPR, and also binding corporate rules. And that's typically used when you're transferring data between, say, branches of the same company that happen to be located in different jurisdictions. There are, as usual, within the GDPR, some exceptions in specific circumstances. So there may be very occasional cases when data is transferred without any of these three being in place. So typically, this would be something where it's vital for national security or criminal proceedings or something like that. So just to quickly flag, the USA does not have a full adequacy decision with the EU. So they're probably one of the countries that within the EU we probably try to share the most data with. There was a recent data privacy framework agreement that came into place, but that's only for the commercial sector and the sharing of data within a commercial setting. So typically, if you are going to be transferring data to the US, you'd be looking at standard contractual clauses. But the issues around the level, there are issues around the level of data protection that your data subjects would have if the data goes to the USA, and that's largely due to rules in the US, which for national security purposes mean that the data can be accessed by the government for basically any purpose that fits within national security. The UK is considered to still be kind of implementing the GDPR. So within the UK, the GDPR, the Act is the Data Protection Act, and it continues to largely follow the GDPR. And so sharing with the UK should be possible in most circumstances. It doesn't present too much of a disclosure, a risk to the data subjects. Okay, so section summary for this one. We looked a bit at the legal basis for processing. So hopefully you've got an idea of that you need one for Article 6 and Article 9 if you're processing, say, data about health or genomic data. And we looked at a couple of those which are likely to be most relevant in a research project. So again, typically, I think it's fair to say most research projects probably rely on consent as a legal basis, but there are other options. And so if it's not possible to collect consent, you may be able to look at something like legitimate interest. If your institution was founded under law to perform research, that could be a basis under kind of public task as well. And then you may want to look at something like 92J, which gives you the ability to process data for the scientific and research purposes, though it does specify in 92J that you then need to think about one of the other articles in relation to data protection as well. We also spoke a little bit about consent as a legal basis and what challenges might be associated with international transfers. Okay, we'll move on to part 3. And so in this part, we want to really think about the roles and responsibilities in data processing. So the two of the key roles defined in the GDPR, you've probably come across them, are controllers and processors. So the GDPR defines a controller as a natural or legal person who is responsible for defining the purposes and means of the data processing. Whereas a processor is someone who processes data on behalf of a controller. And data processing may have multiple controllers if the purpose and means of processing have been defined jointly. So the controllers, therefore, it's their responsibility to say, okay, well, we are collecting this data and defining what the data is, who we're collecting it from, and what we're going to do with it. And the processor, typically what that means, their role would be, they are instructed by a controller to actually perform some processing. So this could be, for example, they perform the analysis on your behalf. They could be providing a infrastructure on which you store the data that you've collected. That would be an example of them being a data processor for you. Anything like that. But the key difference really is about who's making the decisions. A controller can be a natural or a legal person. So this means it's either like a human or potentially an institution or an organization if they are considered to be a legal person. Within research, what we tend to see is that it's the institution which is the controller. So if you are conducting a research project at your institution, generally speaking, the controller is considered to be the institution itself rather than the researchers. But that's not a hard and fast rule. That could vary. And multiple controllers come into place really when you have people working together to define those purposes and means. I think one of the questions that sometimes comes up is around funders and what is their role. And it would vary depending on the role that they've taken. If, for example, a funder was doing something, say, they said, okay, we want this research question and performed and this research conducted, and they defined what the research was and the data subjects and everything like this, and essentially then just funded an outside organization to actually do that research, you'd probably consider them to be a controller. If, for example, you define a research project yourself and say, okay, I want to conduct this research to address this issue, and an external organization gives you money in order to do that, typically then they're not considered to be a data controller in those circumstances, because you've taken the decisions around defining the purposes and the means of the data processing. They're simply providing the funding in order for that to happen. They don't necessarily have a role in or haven't had a role in defining those purposes and means, and so they're not considered to be a controller. So we've got another kind of discussion exercise, and what I'd like you to do for this one is to think about the correct role. So what role do these parties have? So the first question is, we have a research institute is generating large amounts of personal data from study participants. They have decided to outsource the creation of the infrastructure they will use to process the data to an external party. What is the GDPR role of that external party? it turns green. Yes. So exactly for the reasons that in this case, this institution haven't defined the essential means, or it's not been described that they have, and so therefore they would be considered a processor. If you're kind of hosting infrastructure, the GDPR has a very broad view of processing. So just posting it, if you have any kind of influence over the environment, it could potentially be considered processing. Like if you're storing data in like Google Drive or something like that, technically Google is a processor of yours because they're providing the environment in which you're using that data. So next one, we have researchers at 2 universities have designed a project that will process personal data. One of the universities will collect the data, but the analysis will be performed at the other. What is the GDPR role of the first university? In this case, because they've designed the project together, they would be considered to be joint controllers, because they have defined the sort of means and purposes of the processing, and so in a collaborative way. And so this means that we can't have them both. Well, they must have done this jointly, and so that's why they would be considered joint controllers in this circumstance. A research institute has been recruited by a hospital to conduct analysis on their patients' data, so the patients of the hospital, as they wish to better understand the effectiveness of the treatments they offer. The research institute has a relationship with a local university and asks them to support their work. What is the GDPR role of the research institute? Yes, there is a processor. So yeah, so a processor can have sub-processors, as it were. And as Philip mentioned, the key thing to think about when it's deciding between who's a controller and who's a processor or joint controllers is around who's defining the data collection and the data processing. So in this case, the hospital are saying, we want you to perform this analysis that we've designed from these patients, so therefore they're most likely to be a processor. There could be, I guess, a scenario whereby it's done more collaboratively, and the research institute is actually helping them design the research project. But the way it's set out here is more to be a processor, and then the relationship would be with the local university as a kind of processor to processor relationship. So one of the other roles that's mentioned in the GDPR is around the data protection officer. And so it's actually a requirement if you're a controller or a processor and you are processing special category data as one of your core activities. So I think most of us come from research institutions or institutions which are doing research, then you have to have a DPO. Generally speaking, though, there's a kind of an expectation that regardless of whether it's just special category data, you probably will have a DPO within your organizations. Some member state law requires it for other forms of processing as well. A data protection officer, therefore, has kind of responsibility of providing independent oversight of the processing, and the independence is quite a crucial thing. It's generally considered good practice for the DPO to, say, not be a member of the research teams, because, of course, someone who's part of the research team has a vested interest in the research happening, and their role is to be independent of that processing and to kind of advise on compliance. So their responsibilities really then are to inform and advise the controllers or processors around their data processing, so kind of giving them advice on what's allowed, what's not allowed. Also monitoring compliance with the law and providing awareness training, so making sure that the research that's actually happening and the data processing that's happening actually conforms to data protection law. And typically as well, there's this expectation that they're providing some form of training to members of staff at the institution. So you probably, I think most people would have had some form of at least basic data protection training when you joined your institutions around the kind of general principles, particularly if you're institutions which are processing a lot of personal data. And generally speaking, it's the responsibility of the DPO to make sure that the staff of that institution have a good awareness of data protection law as well. They also provide advice regarding data protection impact assessments. We're going to cover those in a minute. They need to cooperate with the supervisory authority, and so the supervisory authorities are kind of the next level up, as it were, and they provide oversight either, say, on a national level or in Germany on a federal state level of the data processing which is happening within that federal state, and kind of ensure compliance with the law again, and also provide certain approvals for data processing to happen. And therefore, it's not just about cooperating with the supervisory authority, but they also are the kind of the point of contact for the supervisory authority at the institution. So if a supervisory authority wants to investigate what's happening at your institution, they would probably contact your DPO first, and then your DPO would speak to the teams which are doing the data processing. Now, some of the responsibilities for kind of controllers and processors are what are called ROPers and DPIAs. I'm just going to talk briefly about these now. So when you're processing personal data, controllers and processors should maintain what's called a record of processing activity. So that's why I've shortened to a ROPer, to describe the data processing that they are responsible for. And this is set out in Article 30 of the GDPR. There are some very specific circumstances in which you wouldn't need a ROPer, but generally speaking, it's going to be required. So in your ROPer, you should really record the contact details and the name of the controllers and those people involved in the processing, why you're doing the processing in the first place, the categories of data subjects, and the types of personal data you're processing. So, for example, a category of data subject could be study participants, or it could be members of staff, or it could be anything like that, kind of a general grouping. And also the type of personal data. So are you collecting data in a pseudonymized form? Are you collecting data related to health? All those sorts of categories and distinctions between the personal and special category personal data. Who is it that's going to be receiving the data? So are you collecting the data and then sharing it on with someone? Are you sending it internationally? What's the legal basis that enables you to share it internationally if you're doing so? What time limits do you have around the use of the data? So are you keeping hold of that data for a particular period of time? Is it, say, you're keeping it for 5 years or something like that? Or is it tied to a particular project? What happens when the data are deleted and destroyed? How does that process work? How long are the data sort of kept in a state which is they're not being used but ahead of destruction? All those sorts of things. And also your TOM, so your technical and organizational measures. So what processes do you have in place in order to protect the data and to the safeguards that you have around the use of the data? So for TOMs, you might be thinking of something like having access controls to where the data is stored or where the data is being processed. So, for example, do you have to swipe to get into your offices? That would be a form of technical and organizational measure that helps in data protection. You may also have things whereby only specific roles are able to access the data, or they might not have the ability to decrypt the data unless you have the particular authorizations. All those sorts of things you would describe in your technical and organizational measures. DPIAs, or data protection impact assessments, are performed when the proposed processing of personal data is likely to lead to a higher risk to the data subjects. And this is covered under Article 35 of the GDPR. And so higher risk typically means here something like you're using a lot of special category data, or you're processing data in a way which is new or novel. So you might be using a new technology or something like that to process data. And because of that, the sort of the risks that might come about from that processing are not so well known. And so it might be necessary to perform a DPIA. And there are kind of template threshold analyses that you can perform to work out whether a DPIA is actually required for the data processing. The one thing I would say is that it's the responsibility of the controller to do a DPIA typically. So if you're only a data processor, it's not something you would necessarily have to worry about, but there is an expectation that you would be supporting the data controller and doing a DPIA. So if you are doing some data processing for someone as a data processor, there are certain risks that are within your responsibility. So the systems that you're using to doing the data processing, if the data's been transferred for you, the people who would be doing the data processing, all those sorts of things are a potential risk. And so you might have to provide information to the data controller so that they can include those risks within their DPIAs. But ultimately, it's their responsibility to produce a DPIA. And the DPIA itself, what you do through a DPIA is you assess the risks to the rights and freedoms of the data subjects, and then also, very importantly, how the safeguards, so the things that you've put in your TOMs that are in place, will help to reduce those risks. And so when you're thinking about risks in a DPIA sense, what you're looking at is what harm could come to a data subject if the data are accessed by the wrong people, if the data are shared incorrectly, or if they're destroyed before they need to be, and what's the likelihood that that could happen. And then by combining those, you get kind of an overall risk for that particular overall score for that particular risk. And then you think about your TOMs and you say, okay, well, what we do is that we have restrictions in place who can actually access the data, and so that reduces the likelihood that the data is going to be accessed by someone who's unauthorized. And we have the technical measures in place to ensure that that's actually implemented. So what you should hopefully get to is a point whereby the risks that still exist have been either mitigated such that they are considered to be very low risks, or that you feel comfortable in those risks. What you don't really want is lots of very high risks still remaining, or risks which you feel actually are likely to be problematic, and perhaps you wouldn't feel comfortable taking those risks on, as it were. So section summary for this one. So we've looked at a couple of the different roles that are defined in the GDPR, and we've seen hopefully what the difference is between controllers and processors. So the key point is who's defining the means and the purposes of the data processing, and how you would decide which role is most appropriate. And I think one of the sort of things to remember is that it's not a case that you could just say, well, I'm a data processor, therefore these things aren't my responsibility, if the kind of reality is that you are a controller. That it's not a kind of a legal defense to say that you're a processor and not responsible to things if you are actually, for example, defining some of the essential means and purposes of that processing. So if you're helping design a study, you can't then step back and say, well, I'm a processor and these things aren't my responsibility, because the supervisory authorities would look at the reality of what happened rather than allowing people just to define their own roles. We've also looked briefly at some of the responsibilities that a data protection officer has. So the key thing is that they are providing this kind of independent oversight of the processing that we do, and they're there to provide advice, particularly around things like the performance of ROPAs and DPIAs. They can provide feedback on those. They usually maintain the overall record of processing activities for your institution as well. So your research project might be completing some ROPAs, but there's probably a broader record and registry of them for all the data processing that's going on across the institution. And they're your kind of intermediary with the supervisor authority as well. And so generally speaking, you wouldn't necessarily go directly to the supervisor authority about a particular issue. You would speak to the data protection officer first and use them as to sort of mediate that conversation. And finally, we looked briefly at ROPAs and DPIAs. So ROPA, record of processing activity. So if you're a data processor or a data controller, you should be recording the data processing that you're doing and why, and the data subjects that are impacted by your processing. And if you're doing data processing which has a potentially higher risk or higher than the normal risk to data subjects, you may need to think about doing a DPIA if you're a data controller. So if you're using large amounts of, say, health data, you probably need to do a DPIA. If you're doing something new and novel, you probably need to do DPIA. If it's something like you're just processing some general personal data around people working in your research team, you probably don't need a DPIA for that, as it's unlikely to be considered highly risky to those persons. So we want to talk now about the rights of data subjects. And one of the key things to remember is that data subjects retain certain rights regarding their personal data. So it's not a case that once someone hands over their data as a data subject, suddenly they're completely out of the picture. They maintain rights going forward. And these rights include sort of obligations on the controllers to provide information to those data subjects around the way that the data is being used, but it also allows for data subjects to influence the ways in which their data are being processed. So the key obligations really are Article 13 and 14. And so these are the obligation to provide information about the processing that you're doing. So if you're collecting data directly from a data subject, that's Article 13, your obligation to provide information. And Article 14 is if you're getting information from other sources, then you should provide information in some way. So for example, if you're using consent as your legal basis, you're speaking to the data subjects, and so you provide information around the data processing there. If, for example, you are collected data from health service or something like that, some kind of central administrative data store, it might be that it's Article 14 if you're not dealing directly with the data subjects, and so you may want to do something like providing information on the website, on your website for your project or your institution around the data processing, how data subjects who think they may be impacted by the processing can get in touch with you to find out more information or to exercise their other rights, all that sort of thing. So it's more like a kind of like a notice that you might provide, or it could be that the organization or the institution that have actually collected the data update them, the data subjects, to say that this new processing is happening. Article 15 means that you have a right to access the data and other related information. Yeah, so you have the right to access the data and information, for example, about where the data controller collected it from if it didn't come directly from you, what they're using it for, who else has access to it, have they shared it with anyone, all those sort of things. The other rights which are kind of useful, well, they're all useful, but perhaps relevant here are 16, 17, 18, and 21. And so 16 means that you have the right to have any errors rectified. So if the personal data that someone holds about you is incorrect, you have the right for them to, they're an obligation on them to correct that information. Article 17, you have the right to be forgotten. So if there's no reason for the data still to exist, like the processing purpose is finished and things like this, you have the right for them to require it to be destroyed. You have the right to restrict processing in certain circumstances and the right to object to processing as well. So typically the restriction of processing would be something like you believe that the information that someone has collected about you is incorrect, or that they don't have a suitable legal basis in order to actually process that data. And so what you can do is say, I don't want you to process that information anymore other than to correct those errors or to, whilst you prove that you have a justified legal basis. It doesn't mean that the data are destroyed. It just means that they can only be processed for those restricted purposes. And perhaps once the error has been rectified or that they've been able to demonstrate they do have a legal basis, then that restriction would stop and the data processing would continue. You also have the right to object to processing. This would typically be the case if the data are being processed under something like legitimate interest as a legal basis. You have the right to object to that being processed. You might, for example, have to demonstrate as a data controller that you do have a legitimate interest to process this data and that that interest outweighs the risks to the data subjects. So to go a little bit more detail about them. So as I say, Article 13 and 14 require controllers to provide information about the processing they are doing towards to the data subjects. Article 13 is data refers to data that's collected directly from the data subjects, and Article 14 is data that's collected from other sources. And so the controller must make data subjects aware of the identity and contact details of the controller. So who do they get in touch with? The contact details of the relevant DPO. So if they have wish to challenge, or they have concerns around the data processing, being able to speak to the DPO is important. What the purposes of the processing are and what the legal basis under which you're doing that processing, who the data will be shared with, how long the data will be stored, and what their rights are and how they can be exercised. And that's something that's very much key, and something that supervisory authorities want to see, is that it's not just a case of saying we're doing this, but also how is it that someone can contact you if they wish to object? How is it that they can exercise their right to be forgotten, or their right to withdraw their consent? All those sorts of things. You need to provide that in really clear information so that people can do that easily. And as it says here, typically this information is provided via the consent forms. So the information that goes along with the consent that that people sign, a privacy notice or statement. So it might be that you put a notice up on your website where you set out this information. Now, Article 15 describes the data subject's right to access information that is being processed. So you have the right to receive a copy of the data that the data controller has. And Article 20 states this must be in a structured, commonly used, and where possible, machine readable format. This can be challenging. I know some of us are obviously working in a genomics setting. So in principle, someone could request their whole genome sequence, and we'd have to provide it in a format which works for them. Having worked alongside some data protection people at various hospitals, they've had to provide huge amounts of medical data just in printed form because the data subject requested this and didn't have a way of actually reading it on a machine. So they might suddenly be surprised there's something like a 400-page document that comes in with all kind of medical data on it for them, but that is their right as a data subject. And alongside being able to access the actual data, they have to be able to access this information as well when requested. So again, the purposes of the processing, the categories of personal data that are being processed, the recipients, the storage people, information about the right to rectification, erasure, and the restriction of processing and rejection, where the data controller obtains the data from. So if you have collected the data without consent, so you've used something like legitimate interest and you haven't actually spoken to the data subjects, they have the right to know from whom you actually got that data then. And also if the data are being used for automated decision making. So again, there is a right to object to this, I think Article 22, for your data to be used in a way which automated decisions about you are being taken. And the thing to remember here as well is that this right is not absolute. And so actually there may be circumstances which access to your information impacts on the rights and freedoms of others, such that it could actually be prohibited, that you couldn't access it. Again, to think to sort of genomic setting, and particularly when it comes to things like hereditary diseases, it could be the case that that hereditary disease is present in your siblings or your other family members, and they may object to you having access to that data, or because they fear that you're going to make that data public, and that would then impact on their rights and freedoms because it would be revealing health information about them. So it sounds incredibly counterintuitive, but there can be circumstances in which data collected from a person can't be released back to them because of the impact that them having that information could have on other people, which sounds very odd, but I think we can see that actually in specific circumstances that could actually be an issue. Articles 16 gives you the right of the data subject, the right to the rectification. So if the data about them is incorrect, the data subject is obliged, controller is obliged to correct it. And Article 18 is the right to restrict processing. And this is often used alongside Article 16. So you could say, well, I request that you stop processing my data until you've actually rectified the issues with it, the errors. Other reasons for you being able to restrict the processing would include that you believe that the processing is unlawful, but that you don't actually want the controllers to delete the data. The data are no longer required by the controller, but they are required by the data subject as part of legal claims. or the data subject has objected to processing pursuant to Article 21. So your right to object, whilst that's happening, you may want to restrict the right to process in the interim. Article 17 and 21. So Article 17 is the right to erasure, and it's sometimes referred to as the right to be forgotten. And so what this means is that data subjects can, in some circumstances, request that the data controller erase personal data held that's about them. So this can be requested under a number of conditions. So, for example, if the data are no longer required for the reason they were collected, you can request that they are deleted. So if, for example, you gave data as part of a research project and it's now the research project is ended, you could request that the controller delete that data. If you withdraw your consent and there aren't any other legal basis which are available, then the data would have to be erased. That you've objected to your processing under Article 21, and it's been proven that there isn't a reason to continue processing, or if the personal data are being processed unlawfully. And Article 21, as I've mentioned, gives data subjects the right to object to processing. It's applicable if the processing is based on 6(1)(e), so public task, or legitimate interest. The data controller has to demonstrate why they have a compelling reason to continue processing. And so that's why I mentioned previously around this idea of legitimate interest. It's not just enough to say, I have an interest in processing this data. You need to show why your interest outweighs the rights of the data subjects, or the need to protect those data subjects. So, for example, again, referring to my own experience, when we used to use legitimate interest as a basis for processing in my previous role at charity, we used to meet with patient representatives, and we would speak to them and say, we're interested in doing this research project. If you were one of the data subjects that happened to be in our data set, they could have been, they may not have been. Do you think that we have a legitimate reason to actually process this data? And do you think data subjects, such as yourselves, or patients in this case, such as yourselves, would object to us processing this data? Or would they feel that actually we're doing something we shouldn't be doing, or that they are not comfortable with what we're doing in terms of the risks to them are not outweighed by the potential benefits to them as patients? And if they came back to us and said, actually, we don't think that this is a valid use for the data, then that's a project that wouldn't continue. We would go back to the drawing board and think about how we can actually improve the benefits to patients such that our interest is compelling enough. Now we have another kind of activity. So we're going to try and match the description of the right to the article as best we can. So section summary. So we've looked at some of the key rights that data subjects have with regard to the processing of their personal data. One of the key things is that the controllers are obliged to provide information to data subjects, so we can try and make sure that the data processing we do is transparent. Data subjects can request access to the data and copies of it. Generally, it's understood that, or generally it's considered that the first copy you normally get for free, but if you want subsequent copies, then you are able, as data controller, to actually introduce a charge on those, as long as it's fair and a reasonable charge, to stop either people just getting dozens of copies every week to annoy you, but also to recompense if it's a lot of work to actually provide the data in a portable format that can be sent to data subjects. And they can also request that there are any errors are rectified. So if there's personal data about you that's incorrect, you have the right to insist that the data controller rectifies those mistakes. And you also have the right to request that data controllers stop processing their data for various reasons. We've looked at some of those reasons. There's always sort of caveats in the GDPR around certain circumstances whereby that might not be the case. For example, generally speaking, it'd be very difficult to say that you request people to stop processing your personal data in a legal case. You know, it couldn't be that if you were presenting evidence of you were let's say you were accused of a crime, and you presented evidence which contained personal data that proved that I was actually responsible, the guilty party. I couldn't say, well, actually, I don't give you permission to process that data in court. Obviously, I would have a vested interest in doing so, but there are caveats around and limitations and when data subjects can actually restrict the processing of their data. Thank you all for coming along today. Hopefully it was useful.